Ms. Mouton, in cause number 25 DCCR 0907. Before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there...
Did this in January 20th.
The competency report's from October.
You found her competent January 20th.
That's what my file reflects also, Judge.
Okay. Maybe we didn't get her back. I don't know why.
She didn't. There's a lot of things there, but
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway, found competent based on that report. There hasn't been any other reports that I know other than the Dr. Capon report from back in October. And so any other issues at this point with regard to competency?
No, Your Honor.
All right. So in cause number 25, DCCR 0907, Ms. Mouton, you're charged with a second-degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the record.
I understand.
Thank you. And then in cause number 25, DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So the second one, same thing, is a second-degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25, DCCR 1468, you're charged with assault on a peace officer, and this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently, and then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm going to make that notation.
But I just signed paperwork refusing 2 years with both of those.
You did. So obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay. So you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial,
Yes, ma'am.
what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Ms. Mouton, listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we have.
I understand.
So, Mr. Rojas, you're released. And Ms. Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Also, hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change
No, Judge, I thought that was a very generous offer.
that you've reached is for a 5-year deferred probation? There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, and that would likely include mental health treatment so that you can stay on the right path and be able to be successful. Is that your understanding?
Yes, ma'am.
Also, that there would be a dismissal in cause number 25 DCCR 0170 as part of that. Is that correct?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Ms. Bailey, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequence of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And that'll just give me more information about you, your case, and that way also everything will be in place for you to have anything that you need as soon as you start your probation with regard to mental health or anything else, okay?
Yes, ma'am.
And so we'll see you back at sentencing. Okay, good. Mr. Rojas, you have Bethany Batten.
Bethany Van.
Oh, she's okay.
Transported, yes, ma'am.
Okay, we'll reset that. You have Relacia Mouton.
Those are rejections, Judge.
Relacia Mouton.
Morning.
Good morning.
Good morning again.
Good morning.
There's 5 cases. I can do. Are both of those? Good morning. Are you Caleb Laskowski?
Yes, ma'am.
And will your client waive the formal reading of the motion?
Yeah, absolutely will, Your Honor.
Get that. Mr. Laskowski, in cause number 21-37917, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 3rd of 2022 for the offense of evading detention with a motor vehicle. And that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of possession of a controlled substance February 16th of 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the offense of possession of a controlled substance on February 16th, 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample on March 29th of 2022 that tested positive for methamphetamines, amphetamines, and benzodiazepine. And is that true or not true?
True.
Count 4 alleges that you provided a urine sample April 14th of 2022 that tested positive for methamphetamines and benzodiazepine. Is that true or not true?
True.
And then count 5 alleges that you were behind in your court assessed fees as of April 13th of 2022 in the amount of $315. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crocker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Mr. Laskowski is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. And at this time, also find sufficient evidence to find you guilty. And at this time, find you guilty of evading detention with a motor vehicle, Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Crocker.
All right.
All right, good luck to you, sir. You can go back to the bailiff. Thank you for being here.
Thank you, Ms. Smith. Yes, sir.
All right.
See, Mr. Brian Lane, you've got Heyman Brandon.
Yes, ma'am. And I need to bring you a few things.
Well, he's here, so we'll.
Hold on, Sarah.
You can go ahead and bring him.
What's that, Judge?
You can bring him.
More.
Good morning. Are you Heyman Brandon?
Yes, ma'am.
And this is 21-36605. And it looks like, number one, Mr. Brandon is charged with first-degree felony offense of murder. And Dr. Rapon was requested to do a competency evaluation. I don't know that we've been back since then. We received that report February 12th.
What?
Over here, February 24th.
All right, so I've already made that
Found him
finding.
competent.
All right, so what's the announcement?
The announcement, Your Honor, is I'm respectfully requesting one more continuance. What I think, after talking with the state, is that we may eventually, at the next setting, request a bench trial. And we're moving into an insanity. I need an insanity evaluation at the time of the offense. So I've got with Dr. Rapon. I'm supposed to meet with him.
Okay.
I just need a little time to get that. The state, after I get that, then we'll move forward and
Okay.
yeah.
Do you think he can get that done in 30 days? Because he's already done the competency. I would
Well,
think he would be able to.
When he came back from the state hospital, when he was deemed competent, I called Dr. Rapon. Dr. Rapon kind of jumped the gun a little bit and thought I was talking about a competency. I already got a competency from ran out and did a competency,
Right.
and then billed me. But then, so I was like, it's like, hang on a second. So,
Okay.
So he's making an appointment with me. So I anticipate next couple of weeks I'll be to him and he'll maybe
We'll do 30 days. And if you don't have that back, let us know right before that court date and we can reset it without you guys having to come here if he's in the middle of getting that report ready.
Yes, ma'am.
Okay. All right. You can go back with the bailiff, Mr. Brandon.
Right now, yeah.
See, Mr. Kevin Lane,
Yes, sure.
you've got Ahmad LeBlanc.
He's in custody.
What is this?
How much?
Ms. Malfino, Ahmad LeBlanc.
Sitting here thinking I could notice a nice young new probation officer.
All right. Are you Ahmad LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered pleas of true to counts 1, 2, and 3 in a motion to adjudicate and on probation for possession of a controlled substance, first degree felony. Hold on. That's not right. On probation for aggravated assault. New allegation is a possession of a controlled substance in Chambers County. And I've received the updated report. It was unagreed. Have you both had an opportunity to review the report?
Defense has none.
Have your,
Any additions or corrections to the report?
None from defense.
only any additional that Ms. Shagwa may have from the probation department, Your Honor.
And is this the one I believe Chambers County rejected the charge.
January 28th, Your Honor.
Okay.
Or refused it.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail in this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while and working a forklift. He does do online classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January 20th, he hired me and then surrendered to the court. Your Honor, his mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products. We are asking that the court, there is another plan to extend him for a year, drop program, and another drug assessment, and we would ask that the court follow that alternative.
Ms. Malfina?
Judge, obviously the underlying offense involving a weapon is concerning. However, it looked like it was an issue amongst individuals who knew one another, probably involving some young women as well. Mr. LeBlanc does not have any criminal history. I hate to see him have felony, but he's also exposed to quite a bit on a revocation of this probation. I would defer to whatever Ms. Shagwa has to add, but I would ask that if he's continued, Judge, that he be extended and possibly have something a little bit more intensive than just the drop program.
Anything to add that's not in that updated report from probation?
I mean,
So, Mr. LeBlanc, you've done so well. Better than most. You've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously, you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true. Find sufficient evidence to find you guilty and revoke your probation. But I'm not going to do that today. I think you've come a long way. You're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. You'll be, You'll be required to enroll in and pay for it and successfully complete the Texas Drug Education Offender Program. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes, ma'am.
Okay. So this wasn't an agreement, so you do have some rights to appeal. You can talk to Mr. Lane about that, and I need you guys to sign this, Mr. Lane, please. But you'll be released, and the first thing you do is go to probation and make sure you get everything taken care of like you're supposed to, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you, Ralph.
So we're going to need this, though, once they all sign it, right? So you just, yeah, if y'all will get this, once you get the signatures, if you'll get it back to Kelly so she can get it filed into the case.
Thank you, Your Honor.
Yes, sir.
Thank you. Yeah.
See, Judge Walker, you have Paul Nelson.
Yes, ma'am.
Paul Nelson.
Yes.
Have a good day. Doing okay?
Good. How about you?
2 days in a row.
I know. Good morning. Are you Paul Nelson?
Yes, sir.
And will your client waive the formal reading of the indictment in each of the cases?
Yes, Your Honor.
Mr. Nelson, in clause number 23, DCCR 1786, you're charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in clause number 23, DCCR 1787, you are also charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with your attorney?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone. State, excuse me. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Nelson is not competent?
None, Judge.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, that you're mentally competent and understand the nature and the consequences of your pleas, find sufficient evidence in each case to find you guilty. And at this time, in cause number 23, DCCR 1786, find you guilty, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 23, DCCR 1787, find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and also concurrently with the Montgomery County cases. Is that correct?
Right.
They'll run concurrently with that as well. I'm handing you the trial court certifications. Those show that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Judge Walker. All right, good luck to you, sir. You go back to the
Judge,
bailiff.
if I
Yes,
may,
sure.
we would ask that the court waive any court costs as he has indigent. If I need to, if the court needs me to inquire about that, I'm happy to, but he's been incarcerated for 2.5 years and he has zero dinero.
What are the typical court cost on a,
200 and something dollars plus this fee, plus that fee. So total in both cases, Your Honor, will be around $550.
what I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly with a process for that, and take into consideration that he's indigent, that you've relayed that, and I will let you know
Thank you.
exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay, thanks, Ms. French. All right, you can go back with bailiff. Yes, sir.
Have a good day.
You'll make a note for me on that, please. Mhm. Mr. Lewis, you have Daryl Burnworth.
Yes.
Good morning.
Come on, Jim.
How are you?
All right. Oh, that's it.
Good morning. Are you Daryl Burnworth?
Yes, ma'am. Burnworth.
Burnworth, and this is cause number 26 DCCR 0038. Mr. Burnworth is charged with theft of property, and that looks like it was titled a first degree felony, but it was amended for the value to be of $30,000 or more, not
Right.
300,000. Is that correct?
That's correct.
What level offense does that make it?
That makes it a third degree.
Okay. Then with everyone's permission, I'm going to make that notation on the indictment. I didn't when I amended it, but that way it won't be confusing when anybody looks at it. So I'm going to take care of that. All right. So third degree felony offense of theft of property. So what is the announcement?
Judge, I have been talking with Mr. Burnworth, and there are some questions that he brought to me in regards to his criminal history that went to the offer that was made by Ms. French at this time. All his history is in Louisiana, so I just need to verify some things first.
Okay.
So if I just get a couple of weeks, I think we'll be able to get this one resolved.
Okay. Any issues, Ms. French?
None at all, Your Honor.
All right. We'll reset it either 2 or 3 weeks, depending on the dockets. All right. You can go back with the bailiff. See, Mr. Lewis, you have William Miller.
Yes.
William Miller.
And this is Mr. Coleman.
Yeah, I think he's the report came back incompetent.
Correct.
Good morning.
Good morning.
Since I hadn't, they're the only cases got reset, so play Tom would say.
That's nice of you. Good morning. Are you William Miller?
Yes, ma'am.
And this is 26 DCCR 0063. Mr. Miller's charged with the offense of robbery. There was an evaluation for competency that was done by Dr. Grimsley, and received that. Okay, the exam date was March 5th of 2026. The finding in that report is that Mr. Miller is currently not competent to stand trial, and that inpatient competency restoration would be warranted for him to regain competency. Is there any other relevant evidence?
Overstood, Your Honor.
Yeah.
Nothing else,
With regard
nothing
to
else from the
competency?
state.
Nothing from a defense.
Then based on that and based on the report by Dr. Grimsley, I am going to find that Mr. Miller is currently not competent to stand trial. Order that inpatient restoration is warranted for competency restoration and that he be sent to the appropriate facility for a period of not to exceed 120 days from the day you get to that facility. So, Mr. Miller, you'll get sent to a hospital.
Thank you.
And they'll get you taken care of so you can understand everything better, and then we'll get you back to take care of your case. Okay? You can go back with the baby.
Oh, thanks. Yeah.
Yes. Jamaldrin Willridge.
Maybe we hold on that one, I think.
Okay.
There's-
Sure. And maybe when the court has a couple minutes, maybe we'll just speak to you.
We're going to hold that for a second.
Okay, hold it. Thanks. Thank you.
Okay, we're going on. That's it. Let me.
And then walk away. What you call it, police.
Would, we're going on all of the counts, it looks like,
Yes, to enhance.
with our. It's going to take me a second. I'll figure it out. Mr. Bell, in cause number 26, DCCR 0139, you're charged with the state jail felony offense of theft of property with previous convictions from September 25th of 2025. The indictment alleges you were previously convicted of theft May 18th of 2018 in 2 cases, and then after that was final December 3rd of 2021. And then the indictment further alleges that you were previously convicted of the state jail felony offense of unauthorized use of a vehicle June 24th of 2019. And after that was final, you were convicted of evading arrest or detention with previous convictions, a state jail felony, November 8th of 2021. And after that was final, you were convicted of burglary.
Today's courtroom proceedings offered a detailed look at how the justice system handles a variety of criminal cases, from plea negotiations to competency reviews and sentencing decisions. Throughout the hearing, the judge carefully explained each defendant's legal rights, the potential consequences of accepting or rejecting plea agreements, and the possible outcomes if a case proceeded to trial. Some individuals chose to reject plea offers, while others accepted negotiated agreements or requested additional time through their attorneys. In every situation, the court emphasized that each decision must be made knowingly and voluntarily, ensuring that everyone understood the legal process before moving forward. These proceedings serve as a reminder that every case is unique, and courtroom decisions are based on the specific facts, evidence, and applicable law presented in each matter. This summary is intended for informational and educational purposes based on publicly available court proceedings and does not determine anyone's guilt or innocence.